Hello everyone, my name is Mir Konan and my US student ID is 240588810. In this video, I will be advising the owner of Haveli House Restaurant about his legal rights and remedies under the Sale of Goods Act 1979, following the serious issues he experienced with the recent furniture purchase after 10 years of running his restaurant. Suleiman decided to renovate the premises and advised Amjad Furniture Store in London to select new furniture. He was assisted by a sale advisor, someone who assured him about the quality and stability of the product he showed him, relying on a representation. Suleiman purchased 25 extra large grey marble tables, 100 plush velvet dining chairs, and a leather sofa set. These items were secured for delivery on 17 September. However, when the extra large marble table, he received a mixture of medium-sized tables and wooden tables. Several of the chairs arrived with visible grease marks and scratches later that day. His daughter sat on the leather sofa and developed an allergic rash, strongly indicating that the material was unsuitable or of unsafe quality. When Suleiman contacted the store to complain, he was told that it was too late to cancel and that he must accept and pay for everything. This advice was legally incorrect, and the purpose of this video is to explain exactly why Suleiman has strong right to reject these goods and seek remedies under the Sale of Goods 1979. To begin with, this is clearly a contract of sale of goods under Section 2 of the Sale of Goods Act 1979. The Act automatically implies certain protective terms into contract where goods are sold in the course of businesses and because Amjad Furniture Store is a commercial seller. These implied terms from part of the contract whether or not they were mentioned at the time of sale. These terms include the requirement that goods must correspond with their description and must be satisfactory quality and must be fit for purpose. If any one of these implied terms are breached, the buyer is entitled to reject the goods, obtain a refund, or claim damages. In this case, several of these codes conditions have clearly been breached. First, under Section 13, the Act, when goods are sold by description, the good must exactly match that description. Suleiman was sure that he was purchasing extra large grey marble tables and dining chairs and in leather sofas in good conditions. When he received instead was a mixture of medium and wooden tables and some chairs that were visibly damaged. This is a clear breach of Section 13. The law takes misdescription seriously and case law support this. In Verley, the buyers were entitled to reject goods that did not match the description provided. Likewise, in a cross Ronanson, even a small discrepancy between described Suleiman case, the description is far from minor. The goods are entirely different from those he agreed to purchase. Based on this, he is legally entitled to reject the goods delivered tables. Next, under Section 14. All goods are sold in the course of business must be of satisfactory quality. This means they must meet the standard a reasonable person who could consider acceptable, taking into account the description, price, and all relevant circumstances. Even though the chairs were discounted as ex-display items, they were still described as being in good condition apart from minor wear, grease marks, scratches, and visible defect scars. Actually, what a reasonable buyer could accept. The sofa presents an even more serious concern as it caused an allergic reaction immediately upon use. Good poisoning, safely risk, or containing hidden defects are not a satisfactory quality. Important case laws such as Roger v. Paris and Clare v. Coley under Western establish that buyers are entitled to reject goods with defects that undermine their quality, appearance, or safety. These chairs and the sofa therefore fail to meet the required standard, and the law entitles Suleiman to reject them or claim compensation. The third key implied term is fitness for purpose under Section 14. This provision applies when a buyer clearly communicates the purpose for which goods are required and relies on the seller's skills or judgment. Suleiman specifically asked whether the sofa was suitable for people with sensitive skin. Someone assured him there would be no issues with the leather. Their assurance created a blinding obligation that the sofa must be fit for that specific purpose. The fact that Suleiman daughter developed a rash showed that the sofa was not fit for the promised purpose. The leading case, Grand Westphalian Knitting Mills, confirmed that when a buyer relies on the seller expertise and the goods caused harm, the goods are legally considered unfit. Therefore, Suleiman has a strong claim to reject the sofa and seek damages for the harm and inconvenience caused. Delivery obligation was also breached under section 27 to 31 of the Act. The seller must deliver the goods in the correct quantity, description and conditions and within the time agreed section 13. Specifically deal with the wrong quantity or mixture goods when the wrong goods are delivered. The buyer is allowed to reject the entire delivery or accept the correct portion and reject the rest. The case of Malpur Flock v. Universal Furniture Sports rejection where the defect goes to the root of the contract. Since the main good Suleiman ordered, the 25 marble tables were never delivered correctly. The breach is fundamental, giving him the right to reject the entire delivery of tables. Importantly, under the section 35 of the Act, Suleiman has not legally accepted the goods merely by receiving them or signing a delivery note. A buyer is only considered to have acceptable goods after having had a reasonable opportunity to inspect them. Because Suleiman identified defects immediately and raised concern right away, he remained with his legal right to reject the goods. Section 35A also gives him the right to partially reject the goods. This means he can keep any of the chairs that are acceptable while rejecting the defective tables, damaged chairs and unsafe sofas. These provisions were introduced to prevent unfair situations where buyers are previously forced to accept entire batches even if any one of the goods conform to the contract. Finally, the Suleiman is entitled to claim damages under the section 51 to 53. Damages can cover the cost of obtaining replacement tables, the difference between the value of the goods he received and the goods he should have received, and any conditional, expensive or businesses, the difference between the value of the goods have received and the goods he should have received. Damages can cover the cost of obtaining replacement tables, the difference between the value of the goods, section 51 to 53. The cases of Hadley v. Baxende and Victoria Laundry confirm that damages must be forcible and flow naturally from the breach given that the Suleiman is running a restaurant renovation. Delia description caused by the wrong or defective goods are clearly forcible and recoverable. If the store refuses to refund him, he may also bring a claim recovery for the price under section 48 since the store failed to provide what he contracted for. In conclusion, Amjad Furniture Store has breached multiple fundamental implied conditions of the Sale of Goods Act 1979, including description, satisfactory quality, fitness for purpose, delivery obligation. These breaches are serious and amount to a repeated breach of contract, meaning Suleiman has strong grounds to reject the goods, partially reject them, or seek compensation. He could notify the store immediately in writing what he rejects, the misdescribed and defective goods, request a full refund, and receive the right to claim additional damages. These breaches are serious and amount to a repetitive breach of contract, meaning Suleiman has strong grounds to reject the goods, partially reject them, or seek compensation. He should notify the store immediately in writing what he reject, the misdescribed and defective goods, result a full refund and receive the right to claim additional damages. The law is firmly on his side and he is strongly protected under the Scale of Gods Act 1979. Thank you very much everyone for listening me.